You just launched a new website, paid a developer for custom software, and got a fresh logo designed. You paid the invoices in full, so naturally your company owns all of it. Except it doesn't. In the eyes of intellectual property law, paying an invoice or signing a paycheck does not magically buy you the copyright. Under European and Belgian law, a copyright automatically originates with the actual physical human being who created the work, and by default, it stays with them. This can be confusing, especially if you look at the United States system, represented by this seal. Over there, they have a concept called work made for hire, where a company can legally be considered the original author of a work from day one. But here, that is not the case. If your company is operating on assets it doesn't legally own, you are essentially building a house on rented land. You are vulnerable to lawsuits, unexpected licensing fees, and total operational paralysis. Let's look at the first common trap, the employee myth. You might think, my employee made this presentation on company time, using a company laptop, so the business owns it. That is incorrect. A standard employment contract buys their time, but it does not automatically transfer their creative rights. The employee is still the physical author of their creations. To actually own those rights, an employer must have an express, written clause in the employment contract that specifically transfers the copyright for defined uses. There are a few narrow exceptions to this. For example, if a developer writes software or builds a database within a non-cultural industry, the law presumes the employer holds the economic rights. But outside of those specific exceptions, if you haven't drafted specialized intellectual property clauses, your own full-time employees technically own the rights to your company's creative output. Then there is the second major trap, the freelancer commission. It goes like this. I hired an independent designer to make my logo. I paid their invoice in full, so my business owns it. Look at this diagram to see how the law views this transaction. The digital file you received is separate from the intellectual property right to actually exploit or adapt it. The invoice buys the file. The invisible rights stay with the freelancer. A Belgian case proves this boundary. This is James Ensor's Les Masques. The court ruled adapting it for a catalog without explicit consent is infringement. The lesson is clear. Without an explicit written document transferring the rights, paying a freelancer's invoice grants your company absolutely zero legal rights to reuse, modify, or scale their work. The third trap catches the people at the very top. I am the founder and director. I coded the software and built the website myself, so my company obviously owns it. What we see here is the strict legal wall between a physical person, the human creator, and the legal entity, the company they direct. They are not the same thing. If the director never explicitly transferred their rights across that wall, the company is technically exploiting the work without a valid legal title. But there is a massive hidden financial opportunity here. By drafting a formal contract to license their work to their own company, a director secures the asset legally, and in doing so, they can potentially access highly advantageous tax rates designed specifically for copyright royalties. Founders cannot rely on assumptions. You must formally and legally contract with your own company to protect the business and optimize your tax structure. To fix all of this, you need to build what lawyers call a chain of rights. This means your business must be able to trace an unbroken, documented legal link directly from the human creator all the way to your company's commercial exploitation. When building this chain, remember the principle of strict interpretation. The law interprets contracts entirely in favor of the creator. Any specific right you don't explicitly write down is a right your company simply does not have. The first mandatory element is the scope of use. The statutory text shows contracts must explicitly list the allowed modes of exploitation, like reproduction or online distribution. You must also define the geographical territory and exact duration of the transfer. The phrase, all rights reserved, acts as a total legal blockade. It means the creator retains every single privilege until it is signed away piece by piece. Hope and paid invoices are not legal strategies. Only meticulously drafted, explicit written contracts can truly secure a company's intellectual property. This video provides educational information regarding copyright principles and does not constitute formal legal advice. You should consult with a specialized intellectual property attorney to audit your specific chain of rights and draft the proper contracts for your business.